Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, we have been following the Death Star of civilian disarmament states. Of course, that is California, and we were able to drop this video out about the 23 pieces of new civilian disarmament legislation that your governor signed into law yesterday. Now, one of the big pieces of legislation was Senate Bill 2, which essentially turns the entire state of California into a gun-free zone. Literally, just as soon as the governor signed it, the lawsuit started filing. The first one to the party, of course, is the Firearms Policy Coalition. So I want to educate you about that lawsuit because it's got a lot of good stuff in there and there's a lot of things that we need to consider. So today, let's spend a few minutes and let's talk about, before the ink is dry, California gets sued again. Okay, back to California we go again. This time we're talking about Senate Bill 2, which was signed into legislation this week by Governor Newsom that will take effect January 1st and essentially turn the entire state of California into a gun-free zone. So regardless of what your concealed carry status is, there is a laundry, and I mean a long, long list of places where you will no longer be able to carry a firearm under any circumstance whatsoever. The ink was barely dry on the governor's signature when the Firearms Policy Coalition dropped the first lawsuit. The suit is Carolero v. Bonta. It is filed in the United States District Court for the Central District of California. It not only is challenging the constitutionality of Senate Bill 2, it is asking for an immediate injunction against enforcement of this law. Now, we don't need to go back and go through the whole Bruin analysis because all of you have geeked out on this channel long enough to know that after Bruin, we have a much more concise way of looking at the constitutionality of gun laws, and absent some type of historical analog, which says that we, at the founding of our Constitution and the formation of the Second Amendment, all that, accepted those types of restrictions, then they are pretty much unconstitutional. Now, as the plaintiffs, the Firearms Policy Coalition and all the other plaintiffs in here put in this case, the Second Amendment guarantees a general right to public carry, meaning ordinary law-abiding citizens may bear arms in public for self-defense. Accordingly, the general right to public carry cannot be restricted absent exceptional circumstances. And really what this argument comes down to, for all of the areas that California is now going to restrict lawful possession of firearms, it really comes down to, hey, when we go back into the history books and we look for historical analogs, not identical twins, but something kind of remotely similar, well, we don't find anything. And as a matter of fact, what the state now does with this new law is it restricts firearms at all private properties unless the owner has expressly granted permission. It essentially reverses the way a right is supposed to work, or as the plaintiffs put it here, rather than presuming licensed law-abiding citizens have constitutional rights to carry, SB 2 does the opposite. It places the burden on individuals to secure consent from businesses open to the public before they can exercise their right to carry firearms for self-defense. And of course, this law is written to having a chilling effect because the default answer for many businesses who just simply don't want to deal with this is, hey, if the state law says unless we give permission you can't do it, then I guess you can't do it. Or as the plaintiffs put it, and the reason the state has sought to flip the default rule is obvious. Given the inertial tendency to stick with status quo, lawmakers should expect that a prohibited unless permitted default would radically expand the private spaces where guns could not be carried. Put other ways, thus California businesses, which might otherwise allow or be indifferent to licensed carry on their property, may stick to the new default. If they do, it might have knock-on effects, reducing preferences to carry and possess firearms more generally as it becomes increasingly inconvenient to do so. The plaintiffs then go through a laundry list of other prohibitions, including places that sell alcohol. Now, they are not saying that there should be prohibitions or should not be prohibitions against individuals who are possessing while drinking alcohol, but if you take a look at this law, it prohibits the possession on any place, including the parking lot, the premises, or anything where alcohol is manufactured or sold. In California, I will remind you, you have a very large wine industry down there, so there would be hundreds and hundreds of acres of vineyards in which a person could not arm themselves. Gambling establishments, casinos, sports venues, amusement parks, museums, all of these are now restricted under Senate Bill 2, and the plaintiffs did an excellent job of pointing out that there is absolutely not one iota of historical analogs to suggest that this is a proper restriction. Hospitals and healthcare facilities, which has actually already been struck down by a couple of courts in other jurisdictions, as the plaintiffs pointed out. As the District Court of New Jersey recently held, hospitals and medical care facilities existed before and after this nation's founding. And as you know, there's a case out there, Coons v. Platkin, which dealt with New Jersey's similar restrictions in all these sensitive places that struck down the hospital and healthcare facility provision. Parks, they're now restricted under Senate Bill 2. And California, you have 279 state parks encompassing 1.6 million acres of land. No guns on any of them anymore, according to Senate Bill 2. But as the plaintiffs pointed out, parks obviously existed before and during the founding. For example, Boston Common is considered America's oldest park and was established in 1634. Oh, in zoos, yeah, the Coons Court also struck those down recently in New Jersey. And then, of course, one of the other big catch-alls, in addition to the private property owners who haven't explicitly given you permission, is any public gathering. Think about that kind of broad definition, any public gathering. And the plaintiffs very correctly point out, this category is exceptionally broad, likely encompassing everything from political rallies to public markets to neighborhood block parties. Public gatherings of all sorts obviously existed at the founding. Indeed, the founders themselves used such public gatherings to speak to fellow citizens about American independence. And in relation to public transportation, again, there is no historical analog at all to suggest that this country has traditionally restricted the carrying of firearms on public transportation. Now, understand that there is acceptance of restricting firearms in certain sensitive places, but sensitive places are not places that government just gets to label nilly-willy. No, in fact, they are sensitive places because of what occurs there. So correctional facilities, courthouses, the security areas of airports, not just anything that Gavin Newsom and the California State Legislature wants to list as a now restricted area. As the plaintiffs put it, SB 2's laundry list of locations renders most publicly frequent areas of California a sensitive place. Indeed, the challenge provision effectively render licensed carry outside of one's home impossible in many circumstances. A Californian taking public transportation to go grocery shopping and then go to the park for a picnic can leave the threshold of her house with a gun but cannot enter any of her other destinations with it. There was no public understanding in 1791 that the government could so broadly restrict licensed public carry in this way. And as the plaintiffs finally point out in asking the court for injunctive relief, in sum, California, defying Bruin, has designed large swaths of public life gun-free zones. In doing so, it ignores the Supreme Court's instruction that sensitive places are few and exceptional. This court should join the growing chorus of cases holding that such broad-based location restrictions on public carry violate the Second Amendment after Bruin. Listen, this is the first of what likely is going to be many, many lawsuits, not only challenging Senate Bill 2, but some of the other laws that Governor Newsom signed into legislation this week. The case, once again, is Carolero v. Bonta. It is brought to you by the good folks at the Firearms Policy Coalition. We will link up all their pleadings down below so you can geek out them on yourself. And, of course, we will keep you apprised of what happens with this case. In the meantime, if you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. If you don't, that's okay. That information is also down there in the description box. In the meantime, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.